I won't go down with the ship. I won't put my hands up and surrender. Welcome to my ship. Today is January 26, 2026, 5:53 a.m. Pirate time. And today we are going to go over a law. The state of Oregon said that I should go over their laws, so we're going to go over another one today. And I'm going to record the screen. Today we're going to go over Oregon Administrative Rule 411-450-0060, and it's about community living supports. I keep being told the same sentence over and over again. They're adults making adult choices. So today I want to stop arguing opinions and let Oregon law speak for itself. Because the law they told me to look up is very clear about who this system is for. Because the laws I'm looking up are very clear about who this system is for. And it's not written for typical adults. It's not written for senior citizens. It's written for children and intellectually and developmentally disabled adults, together, for a reason. This is Oregon Administrative Rule 411-450-0060. Community living supports. Community living supports. Right at the beginning, the law says these supports are funded when they are necessary to permit an individual to live independently in a community-based setting. That sentence matters, because if someone cannot live independently without assistance, the law already acknowledges a limit to independence. This is not about freedom versus control. This is about support because of need. The law defines attendant care services as direct support provided to an individual in the individual's home or community by a qualified provider. Then it lists activities of daily living, ADLs, including bathing, toileting, eating, mobility, monitoring to prevent choking, assisting with decision making. And the law states very clearly, cognitive assistance or emotional support provided to an individual due to an intellectual or developmental disability. That includes assisting the individual with decision making, assisting the individual with decision making, reassurance, orientation, memory, or other cognitive functions. Those are not services for someone fully capable of adult judgment. That is the law acknowledging cognitive limitations. Now listen closely to how the law speaks about children. It says, for a child, the child's primary caregiver is expected to be present or available, and services must support but not supplant the child's family in their primary caregiver role. Why does the law say that? Because children, due to cognitive development, require protection, guidance, and oversight. Now here's the uncomfortable truth. The same types of services, cueing, monitoring, redirection, reassurance, hands-on assistance, are provided to IDD adults for the same reason, not age, cognitive ability. The law explicitly authorizes redirection to divert an individual to another more appropriate activity, and monitoring, observing an individual to determine if assistance is needed. Those words are not neutral. You do not redirect someone who's fully capable of informed consent. You do not monitor someone if safety is not a concern. The law does not pretend these individuals have unlimited judgment. So why does the system? I can tell you why, because they're not paying attention. This rule includes service groups ranging from infant toddler all the way through adult IDD categories. It's developmental, not age-based. This is not about someone who lived independently for 70 years and now needs help. This is about people who never fully developed independent capacity. That distinction matters. Here is the contradiction no one wants to address. The law says, assist with decision making, provide reassurance, redirect when needed, monitor for safety. But the rhetoric says, it's not our job to decide what's appropriate. You cannot be responsible for safety and hands off at the same time. That's not dignity. That's not dignity. That's doublethink. The law openly acknowledges families when it comes to children. But when children turn 18, the needs don't disappear. Only the family's voice does. Parents don't stop being safeguards because a birthday passes. Cognitive disability does not age out. The law already tells the truth. IDD adults are grouped with children because of cognitive support needs. That is not an insult. That is the foundation of the entire system. If we pretend otherwise, we don't give dignity. We remove protection. And my son deserves more than paperwork. He's more than just a box that you check off to get your gold coins, selling your soul. Yeah, I'll be going over more parts of the laws that they think that I need to refresh my mind with. So, sail on, mateys. See you on the next mission. Bye.